nature of our criminal justice system that each defendant must receive a fair trial. For that to happen, the defendant's attorney must have access to appropriate potential evidence. To ensure this right, the United States Supreme Court has ruled that prosecutors must disclose exculpatory evidence, which means evidence that tends to demonstrate innocence. This rule was announced in the 1963 case Brady v. Maryland. In that case, John Brady and his companion Charles Boblet were accused of robbing and killing another man. They were arrested, tried separately, and each convicted of murder. To avoid the death penalty, Brady took the stand and admitted to participating in the crime, but claimed that Boblet killed the victim. To support his client's claim, Brady's defense attorney sought to examine all statements that Boblet made to the prosecutor. Although the prosecutor gave the defense attorney access to these statements, he did not provide him with the one statement dated July 9, 1958, in which Boblet admitted to having committed the murder. Prior to that time, a defendant's rights were only considered violated when a prosecutor behaved in bad faith by intentionally concealing exculpatory evidence or intentionally allowing false testimony at trial. The court's decision in Brady altered the criminal procedure landscape. Although the state prosecutor did not conceal the statement of Boblet out of trickery or intent to deceive, the court reasoned that any concealment of exculpatory evidence violated Brady's right to a fair trial and established the rule prosecutors must turn over, upon request, all favorable evidence that materially relates to a defendant's guilt or appropriate punishment. The Supreme Court in Brady did not define material or offer guidance on how a defense attorney's request for exculpatory evidence should be worded. Later decisions have attempted to clear up any confusion. In Giglio v. United States, the prosecution's primary witness provided nearly all the evidence that established the defendant's guilt. However, the prosecution did not disclose the fact that his testimony was obtained in exchange for an offer of leniency. The Supreme Court determined that this leniency offer was material, and withholding that information from the jury and from defense counsel violated the defendant's right to a fair trial. The case established that evidence is materially exculpatory if it would have reasonably affected the judgment of the jury. Here, the evidence of the leniency offer could have affected the jury's conclusion because it could have cast into doubt the witness's credibility. The court further ruled that it did not matter whether the prosecution intentionally withheld this evidence. Even if it were held negligently, without bad faith, it still violated the defendant's due process rights. The defendant was therefore entitled to a new trial. Material has been subsequently defined as a reasonable probability that if the evidence had been disclosed to the defense, the outcome of the trial would have been different.
From the beginning, many people failed to realize what we meant when we said your son could be next. When actuality, anybody you know could be next. And it doesn't have to be in such a case. Every time we turn around, we see how our rights are being stripped and violated. So my major emphasis has been always, if they can violate R. Kelly, the king of R&B's rights, constitutional rights, publicly, what chance does a person like you or I have? In courtrooms across America, prosecutors regularly withhold evidence from the defense that could blow holes in their cases. That's a violation of the Brady Doctrine, based on a 1963 Supreme Court ruling that requires them to disclose any information favorable for the defense. When prosecutors withhold evidence they are duty-bound to turn over, they undermine the Constitution, the Supreme Court's case law, and the premise of justice. What does that say when they go out of their way to spew such propaganda to limit the probability of a person being guaranteed their right to a fair trial by an impartial jury? Now, many will insist that R. Kelly is receiving his due process, but is he really? considering the fact that a female terrorist group by the name of Mute R. Kelly was allowed to halt so many of his shows, limiting his financial status. Then on top of that, this scripted docuseries was used in order to solicit victims. I say that very lightly. And then you have these people such as the prosecutor and attorneys for some of these people accusing R. Kelly, linking up in private conversations. You have her giving her biased opinion on record. And then you have the fact that they're sharing alleged evidence with CNN News. Now, that's just the top layer of the injustice R. Kelly is facing. Let me remind you of the fact that prosecutors are still withholding evidence which would fall under the Brady. According to this article that was published March 2nd, 2020, they were still rejecting the demands by the defense to hand over this evidence. According to the article then, it said, in a 10-page filing Monday, federal prosecutors fought against efforts by performer R. Kelly to obtain new information about the evidence the government intends to use against him. Kelly faces multiple counts of state and federal sexual misconduct charges in Illinois, Minnesota, and New York, ranging from sexual assault to allegations the music superstar headed a racketeering aimed at supplying him with women. Kelly had demanded a court order seeking the investigative notes of agents, complaints against those agents, and production of so-called Brady material or evidence which is favorable to his defense. I do particularly remember in one hearing the prosecutors stating that the reasons they didn't want to hand over this evidence is because it would help the defense. Sounds a little bit contradicting to the way these people keep putting out the propaganda that they have this abundance of evidence against him. But prosecutors say they already preserving the agent's notes, and they have already provided Kelly's defense and some so-called Brady evidence, and have given assurances that they will provide more if it is discovered. They also noted that they are not in a position to provide information on witness testimony because they do not know which witness they will eventually be calling. The government does not anticipate that the trial will involve the testimony of any law enforcement witnesses, the prosecutors wrote. Wow. With these allegations, they do not intend to use any testimony from law enforcement witnesses. I wonder why. Most of the government's witnesses will be victims and witnesses with first-hand knowledge of the defendant's crimes. I just hope it's not these same witnesses that have already displayed how uncredible they will be. Kelly has also asked for the records of any assistance, financial or otherwise, which has been provided to potential witnesses, but prosecutors said they knew of no such assistance, save for unnamed benefits which has been provided to 2 witnesses by Cook County State Attorney's Office. Kelly was jailed last July and has been awaiting trial at the Metropolitan Correctional Center here in Chicago. The federal charges in Chicago accused the music star of filming himself having sex with underage girls and paying off potential witnesses at the 2008 trial where he was acquitted on similar charges to get them to change their stories. And it's strange that they want to keep bringing that obstruction reference in there, but they want to overlook the fact that they gave a specific person an immunity deal to testify, and her testimony wasn't even credible. So to again use this same individual in these new sets of charges, that should be suspect to a lot of people. Which brings us to today, in which, if you notice, there was a new act passed, and it's called the Due Process Protections Act, and it was signed into effect October 23rd. I just wonder, what will this do in R. Kelly's case, considering we all know that the due process is in order, and it's kind of confusing why they would need to pass a new act to enforce this due process right that we all have. The due process clause is enshrined in our Constitution as a check against government overreach, but there are inadequate safeguards in federal law to ensure that this fundamental right is protected for criminal defendants. Our bipartisan bill will help protect the right of the accused to all evidence that could exonerate them and hold accountable prosecutors who fail to comply. I'm pleased our bill is now law, and I thank Senator Sullivan for his partnership in this effort. Now I'm going to attach this link in the videos, and I want to ask you, what do you think about this new Due Process Protections Act? Why is it that it's necessary to have such an act in place instead of enforcing the already rights we're supposed to be guaranteed? A lot of questions I have, but I'll just wait and see what your comments will be. Make sure you like this video, subscribe if you haven't already, and head on over to my Patreon. All the links will be in the description.